Israel halts aid to Gaza after the first phase of the hostage deal concludes. With critics targeting Israel over humanitarian aid to Gaza throughout the war, it's time to understand the law and the facts. Welcome to Basic Law, a show that dives deep into the biggest news stories affecting Israel through a legal lens. I'm Aylana Meisel, and today we're tackling a critical topic that has been front and center since the start of the war on Hamas: humanitarian aid. This subject is one where emotions run high, as national security concerns often clash with heartbreaking pictures of collateral damage in war. The diplomatic and strategic considerations in supplying aid to enemy territory are also weighty. And specifically, in this case, false charges that Israel is starving Gazan civilians have also been weaponized as a tool for manipulating global public opinion about the war and even affecting the safety of Jewish communities abroad. Today, we focus on an important and often misunderstood aspect of this issue, one which is being litigated in Israeli and world courts and has been for over a year. Under international law, what aid is Israel required to provide to enemy territory during wartime? IDF figures show that over the first 15 months of war, Israel facilitated the delivery of over 1.3 million tons of humanitarian aid to Gaza: food, water, fuel, medical supplies, shelter equipment. As part of the recent hostage deal, Israel boosted the aid deliveries despite multiple and egregious violations of the deal by Hamas. Nonetheless, accusations that Israel has violated international law by withholding or even blocking necessary aid to civilians have been unceasing, and they play a central role in a case against Israel at the International Court of Justice, the issuance of warrants by the International Criminal Court, and even in a case currently in Israel's Supreme Court. And now Israel's strategy has changed. On March 2nd, Israel announced it would stop all aid from entering Gaza, claiming that the aid isn't reaching the Gazan people, but rather strengthening Hamas. This decision has intensified claims by NGOs, public officials, and other states that Israel is violating international law. Time to get to clarity. We're joined today by barrister Natasha Hausdorff, a legal expert with experience in international law and humanitarian issues, to help us make sense of it all. Natasha is the legal director of the UKLFI Charitable Trust in London and a lawyer dealing with public international law, national security, and foreign policy issues on which she lectures and is frequently interviewed. Natasha, thank you so much for being here.
It is my absolute pleasure to be with you.
Before we discuss the Israeli case, can you please explain what international law requires in terms of supplying aid to a besieged population in enemy territory in wartime?
Of course, the relevant provision here we find under Article 23 of the Fourth Geneva Convention, and that sets out that a contracting party to the Geneva Conventions shall allow the free passage of all consignments of medical and hospital stores and objects necessary for religious worship. It will also permit the free passage of all consignments of essential foodstuffs, clothing intended for children under 15, expectant mothers, and maternity cases. But these requirements are qualified. Very importantly, there's a condition that the party must be satisfied that there are no serious reasons for fearing that the consignments may be diverted from their intended destination, or importantly, that a definite advantage may accrue to the military efforts or economy of the enemy through this facilitation effort. That's a very high bar. I'd say quite importantly a high bar, that it is a requirement that the party in question be satisfied that there be no diversion to enemy forces. That's the general provision. And of course, unfortunately, it's very much at odds with what we're seeing in terms of the international discourse in relation to Israel and its obligations towards Gaza.
Well, I just want to go back over the phrasing to be very, very specific. When you say that they have to allow the passage, do they themselves have to supply aid?
Not according to this provision. The terms are to do with facilitating or allowing the free passage of consignments So invariably, this comes from the international community. Certainly, in other examples, in the wars in the former Yugoslavia, the United Nations and other states were providing those sorts of consignments. In relation to Gaza, of course, there's been an international effort, lots of NGOs and states themselves committing significant amounts of aid. And so the question has been, what are Israel's obligations on facilitation? There are no requirements in terms of Article 23 or other aspects of a siege situation that actually require supply from the belligerent party themselves.
And then in terms of the actual delivery of the aid, facilitation, does that include ensuring, as you spoke about the fact that they need to be reasonably sure that they're not going to be in some way strengthening the enemy by provision of aid, right? So to what extent does the requirement of facilitation lead the belligerent party or the besieging party to need effectively to secure the aid once it's delivered to the territory?
So as with most aspects of international law, it's framed in the context of the realities of a situation and perhaps not surprisingly, a degree of common sense. So a party can only be expected to do what is within its power. That's why this provision is quite broad in the way that it is drafted, but in practice, the understanding is that if you have effective control over a territory, there are going to be additional requirements on you, including to supply provisions, humanitarian foodstuffs, medical supplies, and the like. But in the context outside of effective control, where you're only looking at Article 23, then there's no particular specification that you are actually in under any particular obligation to deliver and therefore to actually prevent, say, a terrorist organization in this case, from being able to seize that aid. Because international law is working here on the basis of quite a low bar, a low threshold, the test is whether or not a party is going to be satisfied that there are no serious reasons for fearing that aid is going to be diverted. So it's clear in the way that this is expressed that it's not up to the party to ensure that it's not being diverted, but the only obligation to facilitate arises if aid can be supplied so that it is not diverted away from the civilians and to support the war efforts of the enemy forces.
Okay, so before we actually get to the Israeli case, I want to ask one more question because you mentioned that the requirements are different depending on what you called effective control of the area. I think in international fora, Israel is often deemed to have effective control of Gaza. I'm not sure Israel agrees with that view. Can you explain a bit more about what the phrase means and whether it's applicable here?
Well, if we step back for a moment and just consider the context in which this issue is being discussed, and that is this framework in international law of occupation. So the suggestion that Israel is in occupation of Gaza is, I'm afraid, legally unsupportable. This is a framework that exists under the Hague Regulations and the Geneva Conventions, which regulates essentially a foreign power while it has either seized territory or is in this context, in effective control of an enemy state and therefore that state's population. So in international humanitarian law, a territory is considered to be occupied when it is placed under the control of an authority of foreign adverse forces. Part of the debate around Israel's responsibilities in the Gaza Strip factors on the pre-2005 situation. And this is, of course, before Israel's unilateral withdrawal from that territory. Now, that in and of itself is problematic because if we consider the underlying status of the territory in Gaza, and this goes all the way back to Israel's foundation in 1948, then the underlying status, according to universally applied international law and the important principle or rule of customary international law, uti possidetis juris, really does only leave us with a situation in which there's underlying Israeli sovereignty, including in Gaza, all the way through Egypt's occupation of the Gaza Strip between 1949 and 1967. And so when Israel recovers that territory in 1967, we're not talking about a situation of occupation because this is not foreign forces occupying another sovereign territory. Ultimately, however, all of that is ancient history. Important to be clear on the proper application of international law. But when we look at the subsequent situation after Israel's withdrawal in 2005, there can be no reasonable argument advanced that Israel is in occupation or has effective control over the Gaza Strip. What we have seen is new, invented, supposed international law being advanced by, unfortunately, many detractors of Israel that have sought to stretch the definition of occupation and suggest that because there was an element of control exercised by Israel on goods entering into the Gaza Strip from the Israeli side, so the border that Israel shared with Gaza, that ought to therefore constitute occupation. It's important to be clear that these arguments have never been advanced anywhere else. This is a unique form of argumentation advanced in relation to Israel, and it simply doesn't stand up when one considers this test of effective control, which is often being applied to determine when an occupation exists under the Hague regulations. When we're looking at the post-7th of October situation onwards, this question of effective control is extremely pertinent, and effectively, the manner in which Israel has conducted its armed conflict against Hamas and other Palestinian terrorist groups has meant that it has never been in effective control of any significant parts of the Gaza Strip. It has gone in, it has fought Hamas and other terror groups, and it has then also withdrawn. More recently, Israel has, of course, been in control of the Philadelphia corridor, and therefore Egypt's role, which has been extremely significant up until several months ago, is perhaps less significant. And additional arguments have therefore arisen in relation to Israel's responsibilities vis-a-vis the facilitation of aid into the Gaza Strip. But that, I'm sure, is something we're going to come on to discuss in due course. It's not in occupation of Gaza, even by virtue of its presence in the Philadelphia corridor, and therefore we come back to Article 23 of the Geneva Conventions, which concerns this facilitation requirement rather than actual supply.
So now that we've discussed the law, I want to just quickly paraphrase the past few minutes. In your view, Israel is not in effective control of the territory, so a sort of minimal standard applies to them in terms of the provision of aid, namely that they have to not, in fact, provide it, but facilitate the free passage of certain kinds of necessary goods, and that's effective, and to also be sure that it's not falling into the hands of hostile actors.
Well, let me just clarify on that point. The obligation to facilitate only arises if it can be sure that there's no diversion to Hamas. And here we need to be very clear about the legal requirements and Israel's actual conduct. Because as in many other respects, Israel has been going way above the requirements of international law. And here, despite the fact that it is evident to anyone who has looked at any aspect of this conflict that Hamas has continually diverted aid, and therefore even the obligation to facilitate does not fall upon Israel. Israel has, of course, been facilitating enormous amounts of aid into the Gaza Strip, both before the ceasefire and then subsequently as a result of its agreements within the ceasefire. But that practical, factual scenario in which Israel has been facilitating that aid despite not having an obligation to do so is important to divorce from the analysis of the framework and the obligation to facilitate that does arise under Article 23.
So that brings us to the next question, which is that, of course, Israel's been on trial at the ICJ, the International Court of Justice, now for over a year. There are still warrants issued for the arrest of Prime Minister Netanyahu and former Defense Minister Yoav Gallant from the International Criminal Court. Why are we in these cases? Or to start even in a different place, what is your view of these cases, given that they seem to center on a different interpretation of the law potentially, and hence why are we in these cases?
So let's be clear about what the cases are, because the reasons for each of them are somewhat different. The first perhaps set of proceedings, I would just take issue with the notion that Israel is under trial in any respect across any of these proceedings, because that isn't actually strictly accurate, although I appreciate it's the way that Israel's detractors are seeking to present this. So the first set of proceedings pertaining to these issues are in fact not legally binding in any way. They're not proceedings involving Israel. They form what is called an advisory opinion, which was requested by the International Court of Justice from the UN General Assembly. But the UN General Assembly, in passing this resolution, asked the court to presuppose a host of violations by Israel of international law and then to opine on what the legal consequences of those should be. So the advisory opinion that was produced as a result of this request comes with significant health warnings. First, as set out by the Vice President of the Court, Julia Sebutinde, the court's approach, both in terms of fact-finding and the application of international law, are pretty objectionable. They are, unfortunately, the majority proceeded on an extremely anti-Israel basis, encouraged, no doubt, by the former president of the ICJ, Judge Salam, who has a vicious track record against Israel in the context of his previous position as Lebanon's ambassador to the United Nations. In any other respect, I'm sure, or any other domestic court, for sure, a judge with that sort of history would be expected to recuse himself, but not here at the ICJ.
It's worth noting that he since stepped down to become Prime Minister of Lebanon, I believe, where he's said some pretty antagonistic and aggressive things about Israel in that capacity.
He has indeed. We can come on to, the legitimacy with which, unfortunately, the ICJ and the ICC in due course are left with after so many of these fiascos, including, unfortunately, the way that the ICJ has been led by that judge as president for many months now. But the International Court of Justice advisory opinion, as I say, when it comes with those health warnings, just bear in mind, not only did it essentially wipe Israel off of the map when the majority opinion referred to the contiguous nature of Palestinian territory, it also called for the ethnic cleansing of Jews from East Jerusalem and Judea and Samaria as part of the remedies that it sought to institute for what it regards as an occupation. As I indicated earlier, an occupation which it is maintaining against the proper application of international law, but also uniquely in respect of Israel. So that's another reason I would say that the advisory opinion, which is not legally binding and only really as worthy of as the analysis that went into it, is so very deeply flawed and doesn't really advance the position very much here. The other set of proceedings at the International Court of Justice, which is the court in The Hague that deals with states, is this application by South Africa alleging genocide, and that is still in the preliminary stages. So Israel is not under trial in that respect either. What we have had is a series of provisional measures which have been completely misrepresented in the international discourse and unfortunately in the international media, including suggestions that Israel is plausibly guilty of genocide. The former former president of the ICJ, Joan Donoghue, actually came out in an unprecedented fashion to correct these falsehoods and these misrepresentations and explain that all that had been determined so far in relation to these provisional measures was that the case that South Africa was raising before the court raised plausible rights, so that ultimately it fell for consideration by the court under the Genocide Convention. So we haven't had any consideration of the merits in that respect. And the other issue that you have raised very properly is concerning a different court, also in The Hague, one that deals with individual criminal responsibility, the ICC. And here the issue of aid is extremely pertinent, because the arrest warrants that were issued against Benjamin Netanyahu and Yoav Gallant are explicitly predicated on this false allegation of starvation. Now, my organisation, UK Lawyers for Israel, has highlighted that every phrase of every sentence of the public summary issued by Karim Khan, outlining the information that he put before the court in applying for these warrants, that every phrase of every sentence of that public summary is false. We have also more recently put out a comprehensive review of all of the NGO reports that predicted famine and starvation in the Gaza Strip, which have now been proven to be erroneous. Also including proven to be erroneous by UN bodies such as the Famine Review Committee, which called out IPC reports as being implausible and based on only partial information. So when we come away from Israel's responsibilities and obligations under the Geneva Convention, Article 23, to facilitate the supply where it can assure itself that that supply is not being diverted to Hamas, we look at the flip side of the allegations that have been advanced against Israel, including this allegation of starvation. Now, that is a war crime that requires intent specifically to starve the civilian population. Not only has it been proven now that the actual information seeking to justify this, both in terms of famine review reports, but also in terms of what went to the ICC pre-trial chamber with this application for warrants, is false, but it also subverts the very essence of the crime of starvation, which is intent. And we can see from Israel's conduct and from what has been said by Israeli officials over the course of this war, that everything they have done is to prevent harm to the civilian population and to provide that civilian population with humanitarian assistance, even in circumstances where it is not obligated to do so because this aid is being diverted to Hamas. That has been the position up until a few days ago, and I know we're about to come on to discuss the recent change in policy.
You're right that brings us to the recent change in policy. Now that we're stopping the entry of aid, I don't know for how long, and obviously this could change at any moment, does that in any way change Israel's legal position? Are we legally allowed to do this? And I will add to the question, we should just note that reports suggest that there are at least several months of aid already in the Gaza Strip, such that the idea that we're somehow shutting off the faucet doesn't leave anybody hungry in the next few days, few weeks. And some reports have suggested up to 6 months.
So that factual background is really critical for understanding what the position that Israel is adopting is all about. The recent influx of aid through stage 1 of the ceasefire wasn't as a result of any international law obligations on Israel, but was what Israel agreed to facilitate into the Gaza Strip as part of the ceasefire agreement. And of course, the distribution of that aid was made a great deal easier by virtue of the ceasefire. So by all reports and accounts, the volume of aid that has flooded the Gaza Strip does mean that there is no risk of starvation of Gazan civilians for very many months on the basis of the volume that has gone in, so long as Hamas is not preventing that aid from reaching civilians. That's unfortunately a continuing feature of Hamas's control of the Gaza Strip, but clearly one that Israel has no control over. So the decision at the end of phase 1 to stop aid from going in was essentially taken, as I understand it, as a result of that agreement coming to an end. It is consistent with Israel's obligations under international law in two respects. Firstly, because, as we've talked about, under Article 23 of the Fourth Geneva Convention, Israel was in fact never obligated even to facilitate aid into the Gaza Strip because of the continual diversion by Hamas. It has done so nevertheless in going over and above its actual obligations in international law. But here, in the factual context in which there is more than sufficient aid in the Gaza Strip for those civilians, plainly there is no obligation to continue to facilitate. And so once phase one of the ceasefire came to an end and Hamas refused to extend phase one, in the reports that we've been hearing from the negotiators and the international facilitators of those negotiations, then simply those obligations under the ceasefire agreement no longer continue. That's the long and the short of it. But the factual position, unfortunately, in relation to the levels of aid going into Gaza has been consistently misrepresented in the international media. And there's no excuse for that, because COGAT, which is the unit of the IDF, the Israeli Defense Forces, that is solely responsible for humanitarian provision to civilians in armed conflict, has consistently put out the statistics on the volume of aid going into the Gaza Strip. And until the ceasefire, only 1% of aid trucks had in fact been prevented by Israel from entering the Gaza Strip. And the reasons for that often relate to the fact that there wasn't the ability to properly inspect these vehicles. So unfortunately, not every international aid organization complies with the requirements that these need to be flatbed lorries so that Israeli forces are able to inspect that aid and ensure that it doesn't include munitions for Hamas. The factual position is made perfectly clear by COGAT and its continual updates. In fact, the volume of aid going into the Gaza Strip before the ceasefire meant that, in fact, per individual in Gaza per day, we were looking at significantly over the calorie requirements, or in fact, the calorie guidance provided by the NHS here in England. That story is not the one that one hears in the international media, and it seems to me that these allegations of starvation and of the false information put before the ICC to justify these warrants has in many respects been fueled by the kind of Hamas propaganda that we have had coming out of the Gaza Strip, as opposed to both the realities in the factual circumstances and the realities of the applicable international law.
It seems also that just the capacity to check the aid going into the Strip would be, now it's coming in much faster. There are 5 different entry points. There used to be, I believe, only one. And if you just look at the pre-October 7th influx of aid, even during more peaceful times, we were somehow unable to stop the transmission of materials that were ultimately used to build tunnels and strengthen Hamas, and that got us to the point that we're at now. And so I'm not sure if you're yourself involved in the details of what it would take to try to secure aid today, but it seems like it would be a much greater logistical challenge.
Well, of course, one of the key reasons for Hamas being able to supply itself with Iranian munitions, concrete for tunnels, and essentially build up this terror statelet in the Gaza Strip was contraband through the Egyptian border. And in fact, when I went into Gaza in September, I saw the volume of tunnels under the Philadelphia corridor, whereby all of this material had been smuggled in through Egypt into Gaza. Some of these tunnels were enormous. They were able to facilitate 2 lanes of traffic, essentially, and vehicles transporting these goods underground. And as we went along the Philadelphia corridor, the IDF were drilling every 7 meters, and every 7 meters where they were drilling, they were finding more tunnels. So the notion that Israel ultimately had any control over what was going into the Gaza Strip pre the 7th of October is, I'm afraid, fundamentally flawed. Likewise, the notion that Egypt had no idea of what it was facilitating is also impossible to believe, given that the particular tunnel that I've just referenced, which was enormous, was right underneath an Egyptian command tower. By all accounts, the Egyptian authorities were making a significant amount of money out of these smuggling operations. And one of the key arguments for Israel's continued presence, of course, in the Philadelphia corridor, which was a major bone of contention in the context of phase 2 of the ceasefire negotiations, is this problem of Egypt allowing the flow of munitions and other materials for Hamas's war machine under its border that it shares with Gaza. This is in contrast, I think it's worth just raising, to what is happening above ground, where Egypt has reinforced its border and sealed it to prevent any Palestinian civilians from leaving the Gaza Strip unless they are able to pay extortionate amounts of money to the Egyptian authorities. That is actually contrary to real international law and to Egypt's obligations that it signed itself up to in the African Union Convention on Refugees, which it acceded to in 1980. Egypt is required to facilitate the safe passage of those civilians fleeing civil disorder in the Gaza Strip. And if we're talking about the provision of aid to Palestinian civilians where it will not be diverted to Hamas, the key to this, and the only real answer, and something in fact I was calling for from October 2023, is for a humanitarian zone to have been set up the other side of the Gaza border in Egyptian Rafah, where of course these civilians could have been provided with humanitarian assistance by the international community without diversion to Hamas. Anyone who really, truly, truthfully cares about Palestinian civilians ought to have been making that case, because, as we well know, Hamas has been diverting aid intended for civilians in the Gaza Strip and has also been abusing the humanitarian zones such as al-Mawasi that Israel established by firing onto Israel from within these otherwise protected zones. So when one takes all of this into consideration, it's pretty clear that international law here is being abused and is weaponized, inverted against Israel, that real international law is not being upheld, and that, unfortunately, those suffering as a result of this, yes, of course, Israelis, in the context of those still being held hostage who have been deprived of any of this humanitarian assistance, also Israeli troops who've been seeking to defend Hamas against Hamas fire on these civilian corridors in the Gaza Strip, but also clearly Palestinian civilians who have not been properly provided for, and I'm afraid to say have been abandoned by the international community, by international law here, and who Israel's efforts to support can ultimately only go so far.
So one last question in conclusion, if I might. The situation that you're describing, in terms of the perversion of international law, the weaponization of international law, the events that we've seen taking place in these global governance institutions such as the UN, what do you think underlies the disproportionate attacks on Israel, seemingly a resistance to considering any alternatives that might help save more Palestinian lives in a secure way? I think the easy answer for many Israelis is just that there's some kind of blind anti-Semitism or anti-Israel sentiment at work. But I often wonder whether it isn't also political interest, whether there isn't even more deeply just a shift in the perception of what international law is or should be. And perhaps there are other factors at play. Do you have any thoughts on this?
Well, it's certainly hard to argue against that, considering the unique targeting here of the only Jewish state. But I would say there is a broader aspect which should concern Western civilization as a whole, and that is ultimately unique to this phenomenon of international law. There is a difference between rule of law countries such as Israel, such as the UK, such as the US, where law is properly regarded as a curtailment on government power. Contrast that with the despots of this world, those dictatorships that in fact oppositely view rule of law or law as a means of wielding power. And so throughout the history of international law, which is not all that long, one can see a conflict, a struggle between those two approaches to power, law, rule of law. And as a result, there has been a continuing manipulation by those despots, dictatorships opposed to critical aspects of Western civilization, and a manipulation of international law, so-called, in order to suit their interests. I think it's extremely important in those circumstances that we, especially in the West, maintain a very clear notion of what is real international law, what is based on logic and on principles of rule of law, morality, preservation of life, protection of civilians, and what, by contrast, is being pushed for, including, let's face it, in the Security Council, where Russia and China, have vetoes over what the only law-creating body in the United Nations, the Security Council, to the extent that it issues decisions under Chapter 7 of the UN Charter. In that context, I think we have to be extremely alive to how international law is being weaponized, abused, and inverted by those enemies of Western civilization. And what we've seen playing out in respect of the criticisms of Israel is just one aspect of that.
Natasha Hausdorff, always a pleasure. Thank you very much for joining us. Hope to see you again in the future, and best of luck with all of your endeavors.
Thank you so much, and to you.
And thank you to the viewers for joining us today. We'll see you again for new conversations on big questions facing Israel, including those relating to the Haredi draft and major constitutional clashes happening even against the backdrop of the war. See you soon, and make sure to like and subscribe.